Does anyone want to lead off with some questions around judicial review remedies?
Yeah, Brett, I've just got a point. How on earth do you pronounce C-E-T-I-O-R-A-R-I? Is it Curatori?
It's actually CER, but one of the things that you find, sorry, who was that? Was that John or?
Yeah, John.
John, one of the things you'll find about the pronunciation of Latin expressions in the law is that everybody's got a different way of doing it. People from the southern states tend to have a very different pronunciation style to Queenslanders, and I'm pretty sure everybody in Sydney thinks that their various ways of doing it has to be correct. I pronounce it certiorari, and that was how my administrative law lecturer, who we used to joke had been around since before administrative law started, but I'm pretty sure he wasn't born in the 19th century, pronounced it. So, and that was at Sydney. So, you know, for what that's worth, he probably had some idea. So certiorari is how I say it. Prohibition's obvious. Then you've got mandamus or mandamus. Different people pronounce it different ways. And then hopefully everybody's heard of habeas corpus. Injunction and declaration, you'll all know. Anyone else?
Brett, Paul here. In certiorari, when they're talking about the record, you know, the way they deal with it, can you just elaborate on that a bit?
Okay, so certiorari tends to be the primary remedy that somebody's locked their speaker on. Paul?
Oh, sorry.
That's all right. We just get a bit of feedback. Just makes it hard to hear. Certiorari is the primary remedy that you would ordinarily seek when you're appearing for an applicant who wants to challenge the findings or the legality of the process, rather, undertaken by an inferior court or tribunal. So most commonly, for example, would be the magistrates' courts, or what we call in New South Wales now the local court, but also the what most of the other states I think call it the magistrates' court. Also the what used to be called the courts of quarter sessions, or the district court as we call it in New South Wales, and I think the county court is what they call it in Victoria. I think Queensland still calls it the district court. These are inferior courts, or that's how we refer to them. So you have superior courts and inferior courts. Where an inferior court adjudicates, it is, whilst it's actually a court, so the officers presiding have either been appointed for life or are former judicial officers presiding on an acting basis, whereas tribunals tend to have appointments that are established or finite periods. So I think that the standard is about 5 years, and they're not actually courts, so you don't typically stand when a tribunal member enters a room. There's a lot less formality, but they're both similar in the sense that the powers that they exercise tend to be prescribed. They're usually narrow, so you don't have carte blanche authority to exercise powers over the citizens. It's only in respect of specific matters, and that's where the phrase jurisdictional error comes in. So let's say, for example, you're you're dealing with a state, let's say you're dealing with QCAT, and the tribunal member is asked to adjudicate a particular dispute. Let's say it's over a consumer contract, and the tribunal member finds that there is a consumer contract such that they have jurisdiction, and you're acting for a company who supplied goods to another person who had represented themselves not as a consumer but rather as a person conducting a business, and you say by virtue of that representation by the would-be applicant, there's no jurisdiction for NCAT to hear the case. If the tribunal were to find that it did have jurisdiction, you would be saying it was acting or it had failed on the basis of jurisdictional error, and you would be lodging a summons in the Supreme Court of Queensland asking for remedies by way of judicial review. Now, the first remedy that you would tend to be that you would seek, and practices differ. You sometimes don't actually have to seek the remedy in a formal sense that you plead it, because it's implied by virtue of the fact that the court's exercising judicial review powers, is certiorari. And what certiorari does is it basically uplifts the record, so it takes it out of the hands of the tribunal member and places it in front of the court, which is adjudicating the judicial review proceedings. And what it then does is either, if the judicial review is successful, so let's assume that you guys are acting for a company that says it's not a consumer claim, and therefore the tribunal has no jurisdiction and it should actually be litigated in a proper court, then what the judicial officer would do, the officer exercising the power of judicial review would do, in accordance with the power of certiorari, is to quash that finding of the tribunal that it had power, and that would be that would basically put the proceedings at an end. So that's that first tool. That's what gets the power into, so that's what gets the record into the reviewing court. Has that answered your question? Or do you have questions which flow from that?
Yeah, more or less. There's an exception to that, and I'm just trying to find it, but I can't. Okay, no, I understand. Thanks for that. But I thought there was an exception where the record wasn't used or something.
You're talking about you're talking about the distinction in Craig in South Australia between where relief is sought on the ground of an error of law on the face of the record, or whether or not it's on the basis of jurisdictional error or some of the natural justice / procedural fairness type grounds. Is that what you're talking about?
I think that is it. Yeah, I've been reading Craig. Yeah.
Yeah. Now, Craig.
Yeah, okay, that's fine.
So I'll go into that for you, because it sort of tags onto the question that Kylie is asking about. What does record mean, or on the face of the record mean? Just before I go on to that, Peter, you've asked a question about whether or not you'd only use certiorari where you're dealing with tribunals or courts or appeals of judicial review. That's right. Certiorari is the remedy. So you've got administrative law, and the sort of administrative law that you were looking at in the Asada case is one that deals with the restraint of excessive power by government agencies. The other part of administrative law is, sort of the merits review type administrative law, where you're dealing with tribunals, and it doesn't just apply to tribunals, certiorari, it also applies to the supervisory powers of the superior courts over inferior courts. But it's only in that sort of context, the review of tribunal decisions and the review of court decisions where certiorari applies. You wouldn't ordinarily need certiorari to uplift a record from a government agency, because the government agency is not actually making a decision of record. So what we're talking about when we say record can vary depending on the nature of the judicial review that we're seeking to prosecute. And I'll go into that in just a minute. You'll find it referred to in the notes, and when you actually get access to or when you manage to be able to play the lectures, hopefully that's tonight, you'll see that I deal with it in the lecture as well. But the notion of record is what we're talking about when powers are exercised by tribunals or courts. So, and this is where Craig and South Australia becomes very important for you to understand, and it is a little bit complex. And I suppose the complexity of it arises at a undergraduate level, at least in my experience anyway, because you don't actually have very much context, most of you, about what a record is. Perhaps when you have a practical, some practical experience with how courts and tribunals actually work, you'll get a better understanding of what a record is. But it's basically the document or documents upon which the exercise of power by a court or tribunal is being exercised. So courts and tribunals don't get a power to make determinations without their jurisdiction being enlivened. And how you enliven the jurisdiction of a court or tribunal is generally through what process? Can anybody guess? You invoke the judicial process, certainly, Anthony. What's the actual physical act or step which has to be taken in order for the jurisdiction of a court or tribunal to be invoked? Joel and standing is what you have to be able to prosecute your case. Peter, you're pretty close, and Anthony, you're pretty close. You sort of fill out an application or a form, but the magic word I'm looking for is file. How you invoke the jurisdiction of a court or a tribunal is you file. And it's one of those, just a little bit of legal trivia for you. So significant is the step of filing an application, and you'll all be familiar with the notion of limitation periods, and the fact that you have to, generally speaking, say for sort of serious indictable criminal offences and some species of equitable fraud, you generally have to file your case within 3 to 6 years of the damage accruing in the case of a tort, or in the case of a contractual breach, the date of the breach. Time starts to run, and so you have to actually invoke the jurisdiction of the court within that time period. Now, how you do that is you file. And so significant is that process of filing, and some disputes actually turn on questions of when proceedings were commenced and whether they are inside or out of time, that there's a general prohibition on barristers in our split system of law from filing. So I'm not allowed to file any documents in a court, and the reason I'm not allowed to file any documents in a court is that it's tied up in the notion of I'm not supposed to become a witness. So as an advocate, as a professional advocate who appears in court, it's never my job really to give evidence about things, or to be a very rare occasion. And so in the split system, it's the job of solicitors always to file. And the reason they don't let me file is because my job is to call evidence from solicitors if there's a dispute about when filing occurred, about the date that they actually lodged a document. So by filing, I mean taking a physical document ordinarily. There are some variations in this because there's now electronic filing, but ordinarily and for present purposes we're talking about a solicitor or a party taking a physical document such as a summons or an application to the registry of a court and lodging it and paying the fee. That's the step which invokes the jurisdiction of a court. Without that step, and sorry, I'll go back a step, in the case, for example, of criminal proceedings, it's the filing of either a court attendance notice or an indictment, which invokes the jurisdiction of the court. And without that step being taken, the courts and tribunals have absolutely no power to do anything. So if, for example, by some strange occurrence, simply no document had been filed in a court registry or a tribunal, but a proceeding was adjudicated, and this actually happened in a criminal case quite a few years back in New South Wales. The prosecutor had filed an indictment which had not been signed by a Crown prosecutor, which was a requirement, is a requirement in New South Wales. And then the proceedings went on anyway. What was ultimately decided was that those proceedings were a nullity. So without actually filing the initiating document and a valid initiating document, there's no power for the courts to do anything, and anything which is purported to be done is done outside a valid exercise of power. So how that all relates, it's a long way around to what is a record. That's the starting point for the record. That's what we're talking about when we say the record. Now, there's a distinction to be drawn between what a record is. Everyone with me so far? Anybody who's not following me so far, jump in here. Yeah, so Kylie says, would a tribunal have a record? Both tribunals and courts must have a record. There is always a record. The question is always, what is the record? And this is where the contents of 3.1.2 of the notes becomes relevant. I think that's what you were asking about, wasn't it, Anthony? Okay, good. Well, it looks like everybody's sort of generally following us. So, in Craig in South Australia, and one of the reasons it's an important decision in this area is that the joint judgment of the majority, and I think it was only a 5-court bench, they all agreed with each other, which is why it's such a strong decision, it was unanimous, said that we're explaining the distinction between what exactly a record is. Now, what you need to do is you need to separate out, and one of the reasons that we do judicial remedies at the end of looking at some of the grounds upon which you can seek judicial review, is that you've got to have in your head an understanding about the different types of review. So you've got one of the grounds of review that you can bring forward is jurisdictional error, and we've discussed in previous weeks how that relates to a erroneous finding by a court or tribunal that it has jurisdiction over a particular dispute. And I've just given you an example in the case of, say, QCAT, where that, how and when that might arise. Then you've got breach of natural justice, or what we've more commonly in contemporary administrative law referred to as breach of procedural fairness, such as failure to allow one of the parties to be heard, bias. You'll recall from those lectures the number of sub-elements to breach of natural justice and procedural fairness which are incorporated by those terms, and fraud, which is a species of review. Well, it's really a ground which crosses the entirety of legal practice. So fraud tends to have the same meaning in crime and civil law. It tends to have the same meaning, subject to some small slight variations, across common law and equity. It has the same meaning across administrative law, corporations law, various types of commercial law. So once you understand fraud, it generally applies to all these things, and it is a quintessential Achilles heel of any case. If it's tainted by fraud, then the court tends not to recognise it, subject, of course, to it being able to be proved. Now, what the majority said in Craig and South Australia was that in each of those cases, the record is any relevant material which is placed before the court. So just keep that in your mind. It's a broad cross-section. It's any material. Now, what you have to do is you have to distinguish that from circumstances where it is being asserted that there is simply an error of law. And this is starting to get closer and closer to a strict appeal, for example. Now, what the court said in Craig and South Australia was that except where the legislature has said otherwise, the record, for the purposes of certiorari, will not be as wide as those other grounds. It won't include, for example, the transcript of evidence which is given before the tribunal member or the court. It won't include the exhibits, and the trickier part becomes the reasons for decision. What they were saying in Craig and South Australia is that it is the record is that document or those documents which are filed to enliven jurisdiction. So a modern example or a contemporary example that might be of some relevance to you all, let's take QCAT for example, and let's assume for a minute, taking the consumer claims example that I gave you 5 minutes ago, that you have a party that comes forward and says that they are a consumer. Well, this is in the application, so if any of you have ever seen an application for a tribunal, you put your name, you put the basis of your claim, you give some short reasons, etc., and you tick some boxes to say, whether you want to go to the residential tenancy division or the home building division or the consumer claims division, strata schemes division. So they're all different divisions of these tribunals, and the laws which relate to each of these divisions tend to be different. Now, you only invoke the jurisdiction of the tribunal if you can bring yourself within the laws that apply to one of those divisions. So let's assume for a minute that the applicant, in the case the example that I set out for you a bit earlier using the consumer claims case, came forward and said they were a consumer for the purposes of invoking the tribunal's jurisdiction, and that they had not brought themselves, that they were not, one of the carve-outs didn't apply. So there are carve-outs which say, for example, in the case of trade practices, that you're not a consumer if you purchase goods worth more than $30,000, I think it is at the moment. let's say that you define yourself as a consumer, even though on the application you state that the goods are worth $45,000. Now, the registry might accept that document. It might go before the tribunal, and the tribunal might hold that by reason of the applicant referring to themselves as a consumer, it had jurisdiction, and it might ignore the fact that the goods subject to the dispute were worth more than the threshold. What you would there have, potentially, is an error on the face of the record. The record being, for the purposes of an error of law, just the initiating application and any reasons for decision. So if you were acting for the respondent, as we said earlier, you would come along and you would say, this is not a consumer claim. These goods were purchased by this fellow in the course of A, operating a business, and B, in any event, they exceed the amount of goods which take you within the definition of a consumer for the purposes of the legislation. The tribunal member would then have to issue reasons. They would say, I find for the purposes of these proceedings that I have jurisdiction by reason of the applicant checking the box saying they were a consumer. Now, you would be saying that's an error of law, that the tribunal has erred in finding that they're a consumer simply because the applicant had defined themselves as a consumer. You would be saying that the term consumer, for the purposes of invoking the tribunal's jurisdiction, is defined in the Consumer Claims Act, that it's defined by reference to the Trade Practices Act, which says that if the goods are worth more than a certain amount, then you're no longer a consumer, and that the failure of the tribunal member to factor in that definition into the proceedings was an error of law for the purposes of determining whether or not they had jurisdiction. Now, there's a bit of a crossover here, of course, with jurisdictional error, which I apologise for. I'm trying to give you a more obvious example of where error of law might apply, but there tends to be an error of law leading to a jurisdictional error anyway. But let's assume for a moment that it was at least arguable whether or not a person was a consumer, and you were simply arguing for the purposes of your judicial review application not the jurisdictional excess, but rather simply just the failure to apply the correct definition, then the record that would go before the court would simply be the application and the reasons for decision. They wouldn't include any of the other filing. Now, Anthony says, is there a size limit that the documents which can be filed to initiate a court proceeding cannot exceed? Each court has its own rules about filing. For example, in the federal court, you file what's called an application, which sets out the orders that you're seeking. So usually you start with, you want a declaration, and you have to do this in order. So you'd say a declaration that Law X was contravened, a declaration that applicant was harmed, an order for compensation, etc., etc. And then behind that you have to file a statement of claim, which sets out the basis on which you say your client is entitled to the relief in the application. In most of the Supreme Courts, you just file sort of one or the other. If you're in equity, you simply file what's called a summons. And in most administrative cases, such as where you're trying to seek judicial review, you would simply file a summons. In a common law dispute, so this is where the distinction between equity and common law divisions of the Supreme Courts becomes relevant. If you're in the common law division, say you're arguing over a breach of a contract or some sort of intentional tort, you would file just a statement of claim. Now, these are all the different types of filings which initiate proceedings. In most tribunals, because they're designed ostensibly to be user-friendly for self-represented litigants and to keep costs down, sometimes even lawyers out of it, there's usually a sort of a pro forma form that would look like any other form that you would fill out, and you simply fill that out and you pay the sum and file it, and then they tend to shy away from any strict legal requirements to file a summons or statement of claim. All of these documents, well, the application is, because it's pro forma, is a set length. It's only a couple of pages, usually. In the case of Supreme Court filings, a summons you would tend not to file much more than 1 or 2 pages. It just usually sets out the relief that you're seeking, and has attached to it often an affidavit of the applicant setting out why there's jurisdiction of the court and what the nature of the complaint that gives rise to the putative relief is. In statements of claim can vary in length. For example, when I was at ASIC, we were suing the various banks, Macquarie Bank, Commonwealth Bank, etc., over the Storm financial collapse. Our pleadings in that case were, I think, close to 150 pages. So it was really, really long, complex technical pleading. So there's no established or strict rules about how long a pleading can be, except that the rules are you should plead as briefly as possible. In an employment case I once pleaded against a bank, I had it was only about 20-25 pages, but it was quite a complex industrial case arising under what we call the general protections, and there was no real way. What happens often when you sue the banks is that they try litigation by what they try to do is they try to make the process more expensive and more time consuming than it need be, and so sometimes the trick is to plead more detail rather than less detail, so you don't get hit with requests for further and better particulars, just consecutive requests. So we pleaded this 25-page pleading, and one of the justices of the federal court came on and simply said, "This is the case with the really long pleading," and all I could say was yes, which I think took the wind out of the sails a little bit because he moved on. But the rule is generally, what he was getting at was the general rule that you plead as briefly as possible, because judges want to be able to pick it up, or tribunal members for that matter, they want to be able to pick it up, see what the nature of the dispute is and move on. So that's a really long explanation around records. Hopefully it's given you some practical context about what exactly we're talking about with records and the distinction that they were seeking to draw in Craig in South Australia. Is anybody not with me at the moment? Okay, well, if there's no other questions on that, look, we've got review sessions coming up, so it's a little bit tricky, Kylie. Hopefully with that sort of practical, armed with that sort of practical context or information, you might be able to reread Craig in South Australia, and even the notes, and just get a sense of what it's talking about. So I put it this way, the rule of thumb I find, and why there's a difference in the way that you approach different types of, the way that record is defined differently, or what is permitted to be put before a court exercising the power of judicial review by way of the record, is a matter of sort of practical common sense. For example, where you're alleging breach of procedural fairness and a failure to comply with the fair hearing rule because one of the parties wasn't heard, it's impossible to, I'm hoping it's just you, Jolyn, because I hope I'm not doing a chipmunk voice. it's impossible, for example, for a court to adjudicate whether or not somebody has been afforded procedural fairness and received a fair hearing without actually having a look at what went on. So you obviously, that is what went on during the hearing. So you obviously need the transcript, etc. When you're trying to adjudicate an error of law and whether or not the tribunal has correctly applied the law, you don't need all of the evidence and the facts. All you need is just the judgment which says, here is what I say the law is, and all the court needs is that judgment and a copy of the law, as well as the various authorities which might have considered the law, to determine whether or not what the inferior court did was correct. Does everybody see that? Can everybody see why there's a practical distinction between where you've got just an error of law and where you've got something such as fraud or a breach of the fair hearing rule? Has that helped you, Kylie? Okay. In any event, hopefully if armed with this information, you can go away and have a look at the materials again. And next week we've got a review session. The week after, I'll probably still do some sort of review sessions or something for you all in preparation for your exam. That might hopefully be sufficient just for now on what a record is. Anyone else got other questions surrounding judicial review remedies? How they might work, how they might apply, etc. I'm not sure what you're saying there, Kylie. I might have missed a question. Do you want to just give me the question again? How can the court instruct an inferior court or tribunal, Peter asks while Kylie is finding the question for me. Very simply, by way of judgment. So you'll all recall from your early subjects in legal studies, one of the introductory subjects about the requirements for various courts within the hierarchy to follow the precedents of other courts. All a superior court needs to do is issue a determination or a judgment which says, in my view, the learned magistrate erred in finding, or let's go back a step, the learned tribunal member erred in finding that because the application said the applicant was a consumer, they were therefore a consumer for the purposes of jurisdiction, and the reason that they erred was because there is a definition of consumer in the Act. What the tribunal member had to do was to apply the established or agreed facts to that definition to determine whether or not the person was a consumer, and by failing to do that, they fell foul of the task which was before them, and so I remit this decision back to them to be redecided according to law. And if you go in and have a look at appeal decisions, strict appeal decisions, you'll see that sort of language used over and over. The matter is remitted to the court below to be determined in accordance with law, and then what happens is the successful party ordinarily refiles the proceedings with a copy of the reviewing court's determination, and the proceedings commence again. Does that answer your question? Okay, good. Kylie, confused with declarations and how they differ from orders available under the ADJR Act. So declarations are perhaps one of the most common judicial review remedies, and in fact one of the most common remedies more generally. They're available even where the court's not exercising a power of judicial review, and they can be available in primary proceedings. For instance, if they're quite common in a court of equity, where often the parties are at loggerheads as to what a particular paragraph in a trust deed might mean, or in the federal court where you're seeking confirmation that somebody's workplace rights were injured, then what you seek is a declaration from the court as to a certain state of affairs. And what you're seeking there is simply the court to make findings about what happened, and then either to declare the law or to declare the current state of being. So, it's kind of like in a criminal case, a person is not guilty until they're convicted either by a magistrate or a jury of their peers. They're otherwise presumed innocent. So they may have done something, but they're not guilty at law until it's established. In a civil sort of context, two parties can have differing views about facts or differing interpretations of a trust document, and those are simply their opinions until such time as a court hears the dispute and makes a ruling on what the state of affairs is. And declarations in a administrative law context are not really any different. They're simply the judge exercising the power of judicial review, having a look at what's going on and saying, as a result of these established facts, whether they be, in the case of, for example, the Asada decision, a finding about whether or not the CEO had exceeded its jurisdiction or was issuing ultra vires notices, etc. Or whether it is applying in the context of a review of a decision of a tribunal or a court. It's simply the reviewing court saying, here is the state of play. This is, from this time forward, what has happened. So declaring, that's basically what you should read of a declaration. It's declaring the state of being. Now, you compare that to the remedies in the ADJR Act, which are sort of, there's a crossover. You remember, so I think what you're talking about, Kylie, is subsection C. Is that right? So 16.1 subsection C. Yeah, I think actually that's now I think the point Jolan was making. I didn't understand the icons either, but they're apparently an accident when you use brackets. But subsection C is 1C is really just attempt to codify the common law position. So you remember I've said repeatedly now over the last few weeks at various opportunities that the ADJR Act, like a lot of modern statute, is simply an effort to codify the common law, because obviously the task, think back to before you were students, law students, the task of identifying, firstly, even a relevant book which could tell you what the common law administrative remedies are, and then actually being able to go in and identify by heading, say, or index what section you should be reading, and then being able to digest some of the complexity which is a consequence of 800 years or more of legal evolution in the common law tradition, how you would actually find the correct remedy that you should be seeking where you've been aggrieved by what you would say is excessive government action. What the policymakers and the legislators have been doing at an exponential rate over the last 20 to 30 years is creating statutes which codify some of that law. And they continue to sit alongside the common law. So all you've got in section 16(1)(c), where the Administrative Decisions Judicial Review Act will apply, is a sort of short form of what you already had at common law under the declaration power. Does that answer your question, Kylie? I actually, I know you've all had some difficulty accessing them, but I've actually sort of given an explanation of that kind in the lecture, which hopefully you guys are going to be able to access. I really do not know why you can't access them at the moment, but if everybody can double check that for me over the next 24 hours, if you're still having problems, contact IT in the first instance, and if the problems persist, I'll have to try and come up with another plan. I don't know what that is. As I said, I deleted the previous lectures for week 8 and 9, and I re-recorded them and put them up with lecture 10 last night. So if they're not working, I'm tempted to jump off the top of the building. I don't know how else we might get these things fixed. Sorry, Kylie, I was waiting for you to tell me whether or not that's answered your question. What's left? You need to help me here if you're still confused. In the meantime, John, I'm not sure if you're asking a question 16 and 8D. What?
Yeah, I've just been looking through my notes regarding this, Brett, and as I said, for some reason I've got section 16(1), subsection 8D, but that doesn't seem to be what you've just been discussing.
Yeah, not sure. Well, you might be able to give that some thought and we can look at it next week, John.
I must have misunderstood or mistranscribed something, I think, but because it doesn't really seem to fit with what we're talking about.
Well, the good news, we got still a couple of weeks for you guys to formulate questions that you might still be struggling with. So Kylie says, if an order is made under the ADJR Act, would it still be described as a declaration? Yes, it would. What you do when the orders that a judge makes tend to, in any proceeding, tend to reflect what the advocates. The reason we have a split system in Australia, at least one of the reasons, is that those at the bar are expected to assist, to have a greater understanding of what is required of the judiciary and to be able to assist them to do their job as effectively and efficiently as possible. Solicitors, on the other hand, identify more closely with their clients, understand what their clients need, etc. And then solicitors and barristers work together to try and bridge that divide. Part of the task of a barrister is making sure that they, when they settle or draft at the outset a pleading or an application, a filing, the document that actually enlivens the jurisdiction of the court, that the orders that are sought in that filing reflect what the powers are that the court has. So if you're putting proceedings before a judicial officer by way of judicial review that's a product of the jurisdiction contained in the Administrative Decisions Judicial Review Act, one of the things that you might plead would be, and this is relying on 16.1c for those of you who don't have it in front of you, you would say, 1, an order declaring that the applicant has the right to file proceedings in the tribunal as asserted. Now that's not a particularly good example of how you would actually draft it, but all you'd be saying there is an order declaring that, and you see there the key words, rights of the party, so you'd identify the party and then you'd identify the right. Yeah? That would be the way you'd look at it. In a common law, and this is not particularly significant, we would simply draft a declaration that. So you would, the shorthand for how you would refer to the order in 16.1c would be a declaration. That's what I would say. I read section 16.1c, and in my brain, without even thinking about it, it just says declaration. I read section 16.1a, and my brain just short forms that to certiorari. I read section 16.1d, and my brain just says injunction. So these are all just codifications and sort of common language for what the sort of orders that already existed. But you know, your average person doesn't know what an injunction is. They've probably heard the term before. Probably even the vast majority of first year and perhaps even sometimes second year law students, depending on what subjects they've taken, wouldn't be able to articulate for you what an injunction is or how it works. So you can't expect, and the legislature and policymakers don't expect lay people to be able to do that, so they include terms like an order directing parties to do or refrain from doing. And when you have a look at what an injunction is, that's simply what it is. We just call them mandatory or prohibitory injunctions. Does an order have a legal meaning? It just means an order. It has a common meaning. Everybody knows what an order is, but it refers to an order by a court, obviously, in the case of the ADJR Act. Yes, Peter, you would ask for that remedy in the application. If you were asking for judicial review in the summons that you filed, it would say an order quashing or setting aside the decision of the of Member Smith of the Queensland Civil and Administrative Tribunal that the tribunal had jurisdiction over case number 2015/00015. And then if you needed other consequential relief, like you would probably, I would usually set it out, the way I plead these things is even before I get to that, I plead a number of preliminary declarations that I think the court should make in order to get to that ultimate order of quashing the original decision. So in this case, I might plead a declaration that the applicant is not a consumer for the purposes of the Consumer Claims Act. A declaration that a person who purports or claims to be a consumer is not conclusive for the purposes of determining the jurisdiction of the tribunal. These are not particularly good examples. I'm doing them off the top of my head. I wouldn't actually plead them this way, but each of those sorts of declarations, and by which I mean when I say I wouldn't plead them that way, is the language would have to be tightened up. But I would plead each of these things in order, and then I would get to the end so that the judge could have a look at each of the declarations they've made and then decide if they have made each of those declarations or any of those declarations, should they then quash the decision of the tribunal from which the review is being sought. and you sort of just structure it like a bouncing ball so the court knows exactly why you want the relief. Some people simply plead in order quashing the decision, and you look at it and you say, okay, well, why would I, if you were the judicial officer, you'd be looking at it and saying, okay, but why? Why would I be quashing this? Where are the preliminary steps, the preliminary findings I need to make in order to get to the decision to quash it? So styles differ. It often depends on the nature of your instruction. The way I was taught and the way that I'm now teaching you is that you would plead the detail of each of the steps you need, or you think you need, or that you think you're entitled to in order to get to the ultimate relief. So those can form, so you might see declaration, 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 certiorari. You wouldn't plead it as certiorari, but you would know in your head by looking at it once you become a trained lawyer that where an order is sought quashing the decision of the tribunal or setting aside the decision of the tribunal, that it's by nature of that it is in substance an order in the nature of certiorari, regardless of the form. And then if you looked at an order that said, and I'm looking here for example at 1D, if I read an application for judicial review in the federal court, obviously this would have to go to, which said an order refraining the applicant from enforcing judgment made by Social Security's Appeals Tribunal, for example, I would know by looking at that that really what they're asking for is a common law or an equitable injunction. And we know that, and each of you should be putting that together as well, just by virtue of the fact that I'm explaining to you that what you find in section 16 is simply a codification of the common law. So you learn the common law first, you see what's existed for 800 years, and then you go to the ADJR Act and you see that in 1977 somebody decided to make it more complex, although they thought they were doing the opposite by including these further statutory type orders which really already existed at common law anyway. Yeah, so there are jurisdictions where, for example, you can't plead the ADJR Act remedies in a state court. So you don't go to, these apply to administrative decisions of the Commonwealth. So you couldn't go to, if you're appealing against, or if you're seeking review of judicial action by QCAT, you don't go to the Supreme Court of Queensland saying, I want relief under section 16 of the Administrative Decisions Judicial Review Act. You go to the Supreme Court saying, I want a declaration, or declaration 1, declaration 2, and then an order in the nature of certiorari. So you're relying on the common law. I'm not sure if there's a special statutory scheme in place in Queensland. Thankfully, in New South Wales, we haven't seen the need to codify this. Lawyers know that if they're seeking judicial review or some sort of judicial review remedy, how they go about doing it to restrain New South Wales government agencies or to have review, put on review a decision of an administrative tribunal, and you use the common law remedies and you invoke the ordinary jurisdiction of supervisory jurisdiction of the Supreme Court in that regard. In the case of a federal body, as I've said previously, you could either rely upon the common law remedies and just invoke the jurisdiction of 39B of the federal court, or you can go up there seeking relief under the ADJR Act, and or both. Anyone else? Does anyone feel that they've either asked a question which hasn't been answered, or that they've still got a question that they want to ask? When you say almost there, Peter, does that mean you've got another question?
I'm just unsure of a case where you file for an application and you would file under the grounds of both the Judiciary Act and the ADJR Act at the same time. Because I read in the week 4 material, I think it was, that you were able to do that in certain cases, but I don't know why you would do that.
Sorry, you read where?
In the Creckie textbook.
Yeah, and sorry, not where. What was it that you read that you were confused about?
That you could apply both under the Judiciary Act and the ADJR at the same time. But does that just mean that you can do it at the same time, just not under the same types of remedy?
So 39B in Lyven's jurisdiction, supervisory jurisdiction, it doesn't require the ADJR Act to apply. So the common law sits alongside it. So if you've got if you check each of the boxes that give rise to the jurisdiction provided by 39B of the Judiciary Act, and they were set out in the decision of Justice Middleton in Essendon and Asada, then you can go up to the federal court armed with that jurisdiction, or the court's armed with that jurisdiction. You seek to invoke that jurisdiction by ticking the relevant boxes, and you can put forward your common law grounds. The ADJR Act is a more statutory specific. So if you've got if you tick the boxes which enliven the ADJR Act, you can go up to the federal court through that alternative means. Sometimes both will apply. Ordinarily, if you've got the type of claim which the ADJR Act enlivens, you've already got a common law one. And the common law ones tend to be wider, and they tend to be more natural in their application. The thing about statutory law is that it has to be interpreted. Sometimes the words which are used are different to and mean different things to what the common law terms which are adopted were, and so the ambit of that remedy is slightly different, often not so different that it makes that it weighs at all on whether or not the court has jurisdiction, but still is a different head. So it's sort of, think of it this way. Your aim is to get inside the car. The door on the right-hand side opens by using Section 39B and the common law remedies. The door on the right-hand side opens by using the ADJR Act, but both pathways to the car result on you being inside the car. Is that metaphor too crude, or does that help you?
I just hope it's a Ferrari.
Yeah, well, you might have picked the wrong course. I think you might want the business course, not the legal course. Jody, the whole point of doing an assignment like the one I set you was so that you had enough. I think I was saying this at sort of towards the beginning of the course. A lot of people sort of think that, you know, it's obviously you would do a better job on that assignment now after doing this entire course, but your ability to engage in this course has been made more effective by virtue of your participation in that assignment, because the things I was requiring you to think about and process in that assignment has led you to a point now where hopefully some of you are having that light bulb moment in your head saying, okay, now I get it. Now I understand where we're going, how this all works together. And the fact that you're in that moment now saying, I wish I could now go back and do the assignment, is a product probably of you having to attempt that assignment in the first place. But really the ultimate question is whether at the end of this course you get it. So I imagine there's a great many people in the same boat as you, but it's actually, I think, a good thing that you're at that point. Peter, are you using the question hand?
Yes, yeah, Brett. One thing I'm not sure of is under the ADJR Act, I think you've got something like 28 days to apply. But does that same time limit apply if you enliven the file under the Judiciary Act, or you have like 6 years or something?
That's a really good question. I'm not sure I know the answer of that off the top of my head. Hold on.
I wondered about that in regards to the Essendon case, why they brought it under the High Court jurisdiction rather than the ADJR Act.
Doesn't the ADJR Act allow you to extend time to file with leave?
Oh, I didn't look that far into it.
You have a look. These acts these are usually soft filing dates. So usually they say 28 days, and then they say, you accept with leave of the court. And the way courts work is they tend to evaluate the merits of a case before they decide questions of leave. So if they look at a case and they say, this is an utterly hopeless application, I'm not sure why you're wasting our time, they'll just simply say, we decline to grant leave if you file out of time. Whereas if they hear the application and they say, wow, this person seems like they've been aggrieved, then they'll simply just grant leave, and they'll hear the two things at the same time. That tends to be how it's done these days. So it's good to have in mind those filing deadlines, because some of the biggest, some of the most prevalent complaints made against lawyers and suits against lawyers are often failure to meet filing deadlines. So always good to have these things in your head, but don't get too caught up about them, and particularly not at this level. I don't have, for some reason, my text, my Ready Reckoner text on filing limitations for administrative cases, but I don't think there are any significant ones. I think that if at any time, and it sort of would be repugnant to the whole purpose of administrative law and public law generally, to have a situation where the executive could be permitted to exceed its powers and to negatively affect the rights of the citizenry, but to be allowed to get away with it because the person didn't file on time. That I don't think would be tolerated, and certainly wouldn't be something that most courts would warm to.
Just on this point, now that all the assignments have been handed in your opinion, why did the Essendon case go under the Judiciary Act and not the ADJR Act? Just do you know why? Was there a specific reason?
Because as I've been saying, the scope of the common law is much better than the ADJR Act. The ADJR Act is more confined in its application. One of the things that hopefully you've been learning as you move through this course is how confined it is in its application. So there are more specific grounds on which the ADJR Act will apply, whereas the common law tends to be more flexible. And so the natural inclination of most lawyers, or at least hopefully the good ones, would be to rely on the common law first. And so your facility for that is to say, we want to invoke the supervisory jurisdiction of the federal court over Commonwealth officers, and we want to do that on the basis of these common law grounds.
Brett, can you argue if it's under the ADJR Act and under one of the sections, can you still bring common law grounds and citations as reference when you're doing that, or do you have to rely on the statute?
No, if you're running a case on the basis of if you're invoking the common law jurisdiction, if you're invoking the supervisory jurisdiction in 39B, you tend to run basically common law grounds. If you're invoking the jurisdiction granted to the federal court by way of the ADJR Act, you tend to run ADJR Act grounds. They're not mutually exclusive. It's not as though you have to pick one. You can pick both and run them at the same time. But you wouldn't go in if you had the common law at your disposal. you wouldn't go in and then try and argue the more narrow grounds in the ADJR Act, because you'd be making your job a whole lot more difficult than it needed to be.
What I meant specifically is, if you did go in under the ADJR Act, can you wax lyrical about something, say, Lord Denning said in your argument?
Yeah, look, you could. There may be circumstances where one of Lord Denning's insights has some application to something that's contained in the ADJR Act, and a lot of these disputes turn on one or two words. You know, we're talking about interpretation of very short expressions, or sometimes even single words in statutes or applications or whatever it is, and you know, the common law has application to all sorts of those sorts of things, and that's part of the skill set. It's one of the reasons that this profession exists, but it would be unlikely, I would think, given the historical period of Lord Denning's scholarship. That
was just an example. So it's best to, in that sense, what you're saying is best to just keep them separated. Even if you did apply for Section 16(1)(d) injunction and something under 39B at the same time, you wouldn't muddle each argument.
You would have to. I think I don't want you to get too much caught up in the detail, because it's way ahead of where you need to be at this point. But if you always remember, one of the things I've been saying over and over and over and over in these tutorials is, remember that the common law sits separate and alongside the statutory law, and they work independent of each other. The interpretation of the statutory provisions in the ADJR Act can be informed by the common law. So, for example, if you were asking for the type of declaration which is contemplated in Section 16(1)(c) of the ADJR Act, the law in relation to when declarations might be granted would apply. And probably a better example is, there's a whole body of law surrounding when a court will grant an injunction. 16(1)(d) is basically an injunction. The law in relation to common law or equitable injunctions applies, you would think, as a matter of common sense, to the circumstances in which an order under 16(1)(d) would or would not be made. So things like balance of convenience, whether or not there's a tribal issue, and whether or not there is some alternative type of remedy. These sorts of principles would probably inform whether or not a court would make an order under 16(1)(d). So you've got to be aware in that sense of how they might operate. But you have to have in your head very clearly, if you're arguing both common law relief and statutory relief, that you're sort of running two separate cases alongside each other. It's not a conflux. Anyone else? Kylie, next week's tutorial, I think is, yes, I think it's the same as this week, but I'll send out an email confirming that. I just haven't got my diary in front of me. So can everybody just have another attempt, please, at trying to access those lectures? Do what you can to work with IT. If they're not working, just explain to them that some people can operate them and some people can't. I'm not sure why that is, but as I said, I've had a number of goes now at reformatting them and re-recording them, so if they're not working, there's got to be some sort of issue surrounding how you get access to them. I'm not sure what your question means, Gordon, about filing your participation section of the assessment. There's one more week of participation, which is week 11, when we'll be dealing with access to information and obtaining government reasons, and then after that week, I'll be allocating the marks for participation, and it's an ongoing thing. So participation will be determined by engagement over the entire course.
So we'll have those marks before the exam?
I would certainly hope so. The exam is not until February, and you've got revision in week 12, so they'll probably be out around, or I'll probably be updating them around then. But it's only 10% of your marks, so for the vast majority of you, it's not going to tip the balance. Anyone who's sort of got a credit distinction or high distinction for their assignment has got, something in the order of 25 to 40 marks already, and then the rest of it's coming from your your exam. And for those of you who have been doing the problem questions and attending tutorials, you'll have a fairly good sense of how to go about responding to at least 2 out of the 3 questions, which are problem questions, and then the third one's an essay for those who don't do particularly good with problem questions. But since this whole course and the practice of administrative law generally revolves around problems, as does really the practice of law, we're problem solvers, we should be trying to be problem solvers, some of us are problem makers, then problem solving needs to be a skill set that you've got fairly well at hand by the time you graduate. John, I understand your concern. A lot of people don't do particularly well in exams because of, I think, rushing. I have not set an exam which requires you to rush. You've got to answer 2 out of 3 questions. You'll have 90 minutes per question, so you've got a lot of time to properly think about the question, a lot of time to write an answer for the question, and provided that you properly allocate or split your time between the 2 questions and you work through it methodically, you should have more than enough time even for people who don't do well in exams. But it's really about having followed all the course content and knowing your key cases and being able to go through problem questions. But the best possible preparation for your exams will be to just do problem questions after problem question. So people like John Topless, who have made a contribution to every problem question so far, won't have any difficulties, I should imagine. And I'm not just singling John out there because he's usually first to answer each, but not the only one. There are others who have made good contributions to those problem questions. Any other questions? Any other questions before we call it a night? Practicing the legal citation practices which are set out in the Australian Guide is always a good idea for every piece of legal work you do. Exams are perhaps the exception in the sense that when you are citing authorities for your work in an exam, what we are looking for is that you know the relevant authorities, not that you can rote learn the exact citation. So if you're citing, I don't know, Attorney General and Quinn, I'm not looking for the precise location in the Commonwealth Law Reports or the page number. What I'm looking for is that you know the principle, that you know the principle and how it applies to the relevant ground or the relevant relief, and that you can properly apply it. I'm not interested in whether or not you've got the sort of memory that allows you to correctly identify the volume. But as a general comment, some people did very well in their referencing in the assignments, but it's certainly an area as a general comment that everybody needs to work on, because there was it's one of those things which once you master it, and hopefully you should do that within the first year of your legal studies, you just practice it and it just becomes commonplace. But in the exam, some people were doing things like citing paragraph numbers in the body of text, or referring to a case such as New South Wales and Quinn before they provided the full citation. Some people put judges before case names rather than judges after case names. There's a whole, legal writing is perhaps one of the most critical skills that you need to be able to come away with if you want to be competitive in the employment pool as a lawyer. And one of the first things that somebody reading your work will do, particularly if they're in practice, is pick up on whether or not you've mastered that discipline. And that's something that we can tell usually after reading the first 1 or 2 pages. And if you tick that box after the first 1 or 2 pages, we're then looking at the next level up of sophistication. And what you want to do is build the sophistication of your legal writing so that by the time you graduate, you are putting together the sorts of quality submissions which a prospective employer can look at and say, wow, I'm not going to have to teach this person any of the basics. They know the basics. All I'm going to have to teach them is the practice of law. And you want to have by 3rd or 4th year the sort of articles that you can hand over to an employer and say, here's the quality of work I do. And whilst there's some very good work, as a general comment, if there's something that you should all take away, is that everybody probably needs to go back and have a look more closely at the AGLC. But that's for all your future courses. I'm giving you that guidance, not for the purposes of the exam. Alright folks, well if there's nothing else, we'll call it a night. Thank you all for your patience. See you next week.